Good afternoon and welcome to the Employment Handbook webinar, which is our kickoff for our Employment Handbook webinar series presented by Bugbee & Conkle. Okay. We're very excited about today's webinar. Why is that? Well, because employment handbooks and the policies therein touch all aspects of the employment relationship. That's the first point. The second point is that your employment handbook and the policies are often exhibit number one in any lawsuit that an employee files against your company. So this is a very important part of your job in managing your employees. This is our introductory webinar. We will get into more detail in 3 different webinars in 2019. And one disclaimer, this is not legal advice in today's webinar. This is an educational presentation. Our malpractice carrier is very happy that I just said that. Carrie Ramirez put this together for us. Thank you, Carrie. She's our operations manager. The person behind the voice you're hearing is Carl Habekost. I'm an attorney at Bugbee & Conkle. With us today is Elizabeth Bolduck. Elizabeth?
Hi, everyone. So Carl introduced myself, but I'm Elizabeth Bolduck. I do primarily all the employment and labor in our office alongside Carl. We do a lot of discrimination, leaves issues, and specialize in handbooks as well.
Okay, Elizabeth, you want to kick us off here?
Yeah, so today we're just going to quickly go through the agenda just to let you all know what to expect in this next hour. So we're going to go through what the purpose of a handbook is, kind of what you should do in your handbook, what is the model kind of policy to give you an idea of where to start, what are things required by law to be in a handbook if you have a handbook, and also talk about the NLRB and how that affects handbooks. So that's just a quick overview of some of the things that we're going to talk about today. As Carl mentioned, this is just an introductory webinar, so we're just going to talk about general ideas, policies, and procedures. Later on in 2019, we're going to actually dive deep into some of the issues that happen in handbooks. So don't think just because we mentioned something that we won't necessarily really dive into it later. All right. So I think the first thing that we're going to get into is, why do employers need a handbook? Why are these important? Why should you have one or get one, write one if you don't have one yet? First and foremost, it sets the culture and expectation of your workplace. So this is a great opportunity to bring up company information, your history, a mission statement. So if you can say to your employees why you want them to have the same values as you from the get-go of employment, you both are going to be on the same page. So if you work in a nonprofit, for example, and you say our mission is to X, Y, and Z, that employee knows that they must be on board with X, Y, and Z, and if they're not, maybe that's not the right place for them. Also, maybe if you're a small family business, you can say these are our core values. We really care about these things, and once again, if they're not on board, they know from the start that it might not be the best fit for them. In addition to setting the culture, you should communicate to your employees so they know what is expected from them. So these are kind of the rules that you expect from them, and they must adhere to them throughout their employment. So you can say, this is our disciplinary process from the very beginning, and then later on in employment, say in a year later, they're not like, what? We had no clue that this was a policy. Also, it's a great reference tool. So if you give access either electronically or give each employee a handbook to take home, later on they can read it and reference it throughout their employment. So say they have a question about FMLA, but they don't really know who to contact or who's in HR, or they forget, they can quickly just pull out that handbook and read and refresh their memories, and then maybe ask questions off that. They're going to really filter down who comes to HR and who bogs down management for questions that really should be answered and addressed in a handbook. It's also a great tool for employers. So it kind of is your rule book, and we're going to get into that a little bit, what that means later. But, you know, you have to be consistent. You have to know what it says. And then based on that, you kind of know how to handle situations when they arise at work. Carl mentioned this also in the beginning. It reduces legal liability. So it doesn't completely eliminate legal liability. Just because you have a handbook doesn't mean you're not going to get sued. Let's be honest. Anyone can sue you, unfortunately. But it definitely reduces it. So if you have clear policies and reporting procedures, that's the first thing the EEOC or the OCRC or some judge is going to look at when they said, did something wrongful happen at work? So when you have these policies, procedures put in place, it can actually protect your company. However, they can also be a pitfall, which Carl's going to get to in just a minute. All right. Yeah, so kind of to continue on the train of thought that we were just on, you know, when we were talking about it's a reference tool, it also orients new employees. So when you're brand new to our work site, you're getting a lot of information and it's kind of information overload. So it's a great tool to give new employees so they can kind of navigate the new waters of employment. It also provides consistency in the workplace. So if you set one rule and procedure, just make sure you follow it. So that way everything is consistent. You handle things in a routine matter, and it now becomes a business practice, which is another great thing when it comes to legal liabilities. Because if you say we treat this person and in this scenario the same, and this is a policy that we follow, you know, people aren't going to have as many claims as they might if you don't have anything. It also sets expectations. So I think I talked about this just a second ago, but people will know what is expected of them and the rules that they must follow. It reduces confusion. So, you know, if someone doesn't know what PTO is given to them and there's no policy to say anything, you know, when they're sick or they need to take their kids to the doctor or they want to go on vacation, they just really don't know where to start, where to go, and how to request that information. So when you have it in a handbook, it just lets employees know exactly what are their rights, what are their responsibilities, and what are their obligations. It also provides leadership with guidance. So I think I mentioned that earlier, but it's just a tool for employers to, you know, really help them be in a leadership role.
A bad handbook actually is worse than not having one at all. And as Elizabeth just talked about, having a handbook that is not applied appropriately or consistently is very bad as well. You can have consistent policies throughout your handbook, but if you apply those policies or apply discipline inconsistently, that creates all kinds of problems. If you're not careful in the language in the handbook, it can end up creating contractual obligations that you don't want. So finally, we see this regularly since this is a regular part of our practice, reviewing and revising handbooks. The law changes all the time. That's one thing that you can count on that is always consistent, and that is the law is changing. It's dynamic. It's not static. So provisions in your handbook that may have been lawful in 2018 might become unlawful in 2019. So the handbook needs to be reviewed regularly. And I know we talk about this later on in the webinar, but I'm going to go ahead and say it now. Whenever you review or revise your handbook, make changes to it, you need to somehow communicate that to your employees and have them acknowledge the revision so that you've got documentation that they know the handbook was revised. So, unfortunately, we run into this on a regular basis. Some handbooks can go 100 pages, which is amazing. You do not need to put every little policy or thought process in your handbook. You do not need to provide every scenario for a manager or a supervisor and how they handle that scenario. If you need detail like that, put that in a separate rule book or a separate policy manual. The employment handbook really is sort of a playbook, just as we're talking about in our football theme today. It's a playbook. It's cryptic in many ways, that to the extent that it's a guidebook for the employees and supervisors to kind of look at and know where to go. Like guideposts, where we're going down the field. Oh, we ran into an FMLA issue. We know we're going to go to page 25 of the handbook, and that's going to explain how we handle that. So a handbook is not a substitute for training. You have to continually train. It's not a law manual, so you don't need to have all kinds of legalese words in there that people don't understand. And it reminds me while I'm talking about it, if you have a workforce that does not have English as their first language, you should consider having the handbook written in Spanish or whatever language that is common to your workforce.
Yeah, and just because there is a law, that's an employment law, that doesn't have to go in there. Just Irby law in the world, we see that cited over and over again, that, people just put a citation to this law because it is an employment law. So, it doesn't have to cite every single employment law in the world.
Like it doesn't have to cite CFR, Code of Federal Regulations, Section 1904, blah, blah, blah.
Yeah,
right.
Carl and I don't even know what that is. We have to look it up.
I'm just making it up.
Employees, definitely don't know what it is.
Exactly. Okay, move on.
So I think that's a good segue to the common mistakes that employers put in their handbook. And, it's really hard to craft the perfect handbook unless you really know what you're doing. So the first and foremost is to know your workforce. Know what is happening in your day-to-day operations. So a lot of times employers will say, we just need this policy, but they can't describe to us what's actually happening at the workplace. So make sure your attendance policy actually reflects what's going on in attendance trends in your workforce. You don't want to have a really strict attendance policy if you don't have an attendance problem. Now, if you have a really bad attendance problem, you're going to really want to isolate why is that and how do we correct those behaviors. So when creating these policies and procedures, you're going to want to set your tone, and the way you use your language should be the way your operations actually are run. So if you have one type of culture, you're going to want to make sure that type of culture and that language is a flow over to your handbook. So one of the biggest things that I see is that people take these handbooks that are really harsh language that has nothing like the leadership, that doesn't sound like the leadership. So write it in your own language. You don't need to sound, overly sophisticated. Like Carl said, you don't need these legal phrases or legalese. Like, write them in plain language and to reflect your workplaces. Also, they need to be tailored. So I think a lot of times people Google, or they have maybe insurance carriers that provide some sample language, but once again, that actually doesn't capture what's happening in your workforce, and therefore you just have these policies that you have to enforce, but maybe you don't want to enforce because it's hurting you, or that it doesn't make sense because those things aren't happening, or when they happen, there's no exceptions. So definitely make your own policies, outlining your objectives, so that way you can actually really get at what you want, rather than just saying, oh, we need an attendance policy, we need a leave policy, so here's one that we've got in a sample. Of course, you can take those samples and modify it, but don't just copy and paste. One size does not fit all. If you're a small business, your handbook should look a lot different than a Fortune 500 handbook. That's just really the reality of it. All right. So the next one is over or under inclusive. So we either see handbooks that are maybe like 5 pages, 10 pages, or 175 pages. I mean, I read for a career most of the time, and I can even not make it to the last page of a 175-page handbook. So employees can't even do that, right? It's information overload, and they're not going to really know what it says. So you're going to make sure that all the policies you have in there actually are policies you need. So if moonlighting, working another job is not an issue, don't put it in your handbook just because someone said, oh, there's a policy out there. If you don't care about dress code because no one sees your employees and it's not a safety concern, then maybe that should not be in a handbook and only addressed later if it becomes an issue in a separate policy. So that would be, you know, the over-inclusive. The under-inclusive is not having enough. So when you have an issue arise, you don't really know how to address it. So that would be maybe like leave issues. Some people don't have any pay time off, which is okay if you don't want to offer that, but it's not captured in a handbook, and therefore people are left confused. So another one is conflicting policies. So this is when two policies say different things. Which one is, you know, more authoritative? Which one do you follow? And that is a big red flag. You're going to definitely want to make sure all of your policies make sense and follow one another and defer to one another. So, you know, I've seen handbooks that have actually policies put in there twice that say different things. So you just want to make sure that that's not happening. Usually that comes up when people are just copying and pasting from different handbooks that they think, oh, this sounds good, we'll get to it. And so typically that's just a oversight, but it does happen more than you would think. I think we've mentioned this before, but policies are not written in plain language. So there's a lot of authority out there from the NLRB, the EEOC, and other administrative agencies that say, you know, forget these legal phrases and the legalese. Like, you want your employees to know what you're talking about. So just make sure it's written as plain as possible so you can communicate really what you're trying to say.
More common mistakes are that we continue to have unlawful policies because they're worded incorrectly. The biggest thing, though, that you want to be careful of is that you don't lock yourself in and remove discretion that you have as an employer. You know, employers have rights. It is your company. So you do have authority to operate and act as you see fit and as you want to do, as long as you're legally compliant. When you use certain language that that does not allow for your discretion, that gets you into problems. We will touch base on that towards the end of this webinar and give you some examples on that. I'll just give you one quick example. You can have a disciplinary action policy that says you will be disciplined according to this formula: verbal warning, written warning with suspension, and then termination. And if somebody commits a violent act in the workplace that clearly presents a safety risk to your employees, you don't want to give them a verbal warning and then a written warning. You want to terminate them if it's significant what they did. But depending on how the language was written in your handbook, you may well have tied your hands if you don't give yourself discretion by saying, this is the generally recommended formula, but we reserve the right, totally within the company discretion, to accelerate immediately to termination depending on the facts. Failure to update is also a problem. I'll give you an example. The Me Too movement, that has really changed the environment for sexual harassment and sexual discrimination. So you may want to take a look at your discrimination policy and update the language and actually train on it and document the fact that you trained. What I'm looking at right now from the EEOC website indicates that there has been a 50% increase in lawsuits alleging sexual harassment over fiscal year 2017. So over the last year, that's increased significantly. That may be an area that you want to update in your handbooks. And finally, and importantly, it does pay to have a lawyer review. A little bit of money can save you a lot of money down the road. There used to be, as Tybo Wilhelms in our office used to say, as an oil change guy, you can pay me now or pay me later. Pay a little bit now to have a lawyer make sure that the language is compliant, or you can pay a lot later defending a lawsuit. Legal compliance tags along right with what we've been talking about. Every handbook should address these issues. With the disclaimer, what that means is that the benefits, if you have health insurance, and you talk about that in the handbook, and life insurance, maybe sick leave, short-term disability, etc., the ultimate language is going to be found in the benefit package and not in your handbook. So you need to say something along the lines of any conflicts between the handbook and the benefits package would be resolved by going to the language in the benefit package. You definitely have to have anti-harassment, anti-discrimination policies, EEOC policies. By the way, I'm sure everybody out there knows what we mean by that, but that's the federal agency created by Congress under Title VII to administer anti-discrimination laws. It's the Equal Employment Opportunity Commission. FMLA is the Family Medical Leave Act that provides leave for individuals with either a serious health condition or a family member with a serious health condition. You'll want to lay out your vacation pay policy, and the language you use in there can make a difference as to whether you have to pay somebody when they leave employment. So earned versus accrued makes a big difference. Plus, every state has different laws on vacation pay. And then finally, sick and personal day policies. That's important. And I guarantee you, one of the first places your employees are going to go is to the vacation pay policy and sick and personal day policies. In other words, time off. So you need to be very clear when you're addressing time off.
Yeah, so and to kind of echo everything Carl's already said, and the reason this is titled Legal Compliance is these are areas of the law that are really nuanced, meaning that one slight phrase or how you write the language to address these policies can be actually really, really, really important to employers because, as Carl says, one has one impact or one has a different impact. Also, there's some rules and laws out there that require certain things to be in a handbook if you have one. So those are things such as the Equal Employment Opportunity Statement, which we're going to get to in a moment. But these are all things that you really need to be careful and really look over if you have these policies because, there are things that change really frequently in the law, and you want to make sure all the language is actually lawful. All right. So now that we've kind of given you a background of what a handbook is, what it shouldn't be, what are the benefits, what are, maybe some of the disadvantages of it, we're going to start diving into kind of those things that are actually in a handbook. So, what does a handbook look like? A handbook can actually look like whatever you make it. However, this is kind of a module that we're going to go through really shortly to kind of give you a structure. So as long as you structure a handbook, you do it however it makes sense to you and your workplace, but this is kind of the model. So first you're going to have your introductory statements. This is going to include disclaimers, things that this is employment at will. This doesn't have, this isn't a contract, that employer retains the right to modify the handbook, but also to discretion to enforce the handbook. So, it can read policies in its favor if it wants. Things like that. So you're going to want to do that first and foremost. Like I said earlier, those mission statements, company history. If you give handbooks to certain jobs, so like nurses or staffing, and it's specific to one position, you might want to put work information about it, job description, it kind of whatever suits your workforce. And then you're going to want to go to your employment practices after that and policies. Next, you're going to go towards the rules for our day-to-day procedures. You're going to want to lay out what your benefits are, what your leave policies are, rules and regulations, what happens if separation is going to happen from the company. So if someone voluntarily resigns from employment, if someone is terminated from employment, do they have to pay something back? Do they have to return things like that? And then, of course, you're going to want to make some final closing statements. And then also, really importantly, and we're going to get to it later at the end of the webinar today, is receipt and acknowledgments, what to do with those, why those are so important, and what should be in those. So yeah, I think we kind of quickly just went through it. But again, the introductory statements are your welcome statements, company history, your disclaimers. I think we actually went through all that. So Carrie, we can go to the next slide. So I may mention that there are certain things the law requires you to tell your employees. One way to do it is through a handbook. One of those things is the equal opportunity. And this is basically to say that we have equal opportunity in all aspects of employment. So hiring, firing, promotions, things like that. So there's no discrimination provision. You're going to list all the protected classifications. You're going to want to make sure that you include all of them. So a lot of times employers are not familiar with maybe changes in the law. So they don't list them all. So that's kind of why it's important to have a handbook reviewed. Specifically right now, who knows what's going to happen on the horizon about whether sexual orientation and transgender status is going to be protected. So there's trends moving in one way. So we're likely to see how the EEO statement is going to change in the next year or so. And then how to report a complaint of harassment. Just a little nudge that we do have a separate harassment where we're going to actually get into the weeds of what anti-harassment, anti-discrimination policies should look like later this year, but we just wanted to quickly address it here.
So we are going to talk about all the nuances in discrimination and delve into the transgender issue. That we're doing that next year.
That's right. Okay. Yep. So a little teaser for now for you all. We have to give you enough that you're interested later next year, but we will go into those issues really specifically. And I'm sure there will be a lot of questions, and hopefully I think we're doing that, Carrie, in September. I'm sure by September we'll actually have more knowledge of what's happening in those areas. So definitely stay tuned for that.
Well, we recommend that employment handbooks touch base on some of these areas. Workplace violence. Oh my God. When I was growing up, this was not really an issue. When the first jobs I had, we didn't really worry about violence in the workplace. Violence in the workplace would be where two guys just got mad at each other, took it to the parking lot, got into a fist fight, and then probably went and had a beer and everything was fine. Now you have to worry about people bringing weapons into the workplace, and we will touch base on this next year, but one of the most significant issues for women is domestic violence being brought into the workplace. And you need to have policies. How are you going to handle that? How do you handle bullying? And when does that become violence? So, and then how do your employees relate to each other? What do you want to say in your handbook? That, once again, might touch on bullying, or do you want to have policy against family members working together at the same place? Dating, you want to have policy against that. Drug-free workplace, that's going to become an issue. We will talk about that in more detail in 2019. Michigan just passed a recreational marijuana law. They already had a medical marijuana law. Ohio's medical marijuana law became effective in September, and the actual first crop of marijuana plants should be in the process of being harvested by the end of December, and it will go to the dispensaries. So sometime next year, April range, employees will have medical marijuana cards, and they will be taking medical marijuana. And how are you going to handle that? It's something you need to face. You can't put your head in the sand like an ostrich and pretend it's not happening. So these are issues that you really need to address. Pay. The overtime provision and that's still being worked out by the Department of Labor under the Fair Labor Standards Act. I don't know. We don't have a final policy on that yet, do we, Elizabeth? Like the amount of money, the floor for the amount of money that somebody's paid?
Nope. So there's some movement on what's happening there, but as of right now, nothing has changed. You know, the politics in D.C. right now are kind of always, right now, definitely changing. So it's hard for us to know exactly what's going to happen. Of course, we can kind of guess. But with all the political changes that happened a month ago, it kind of put things on hiatus, especially if the government shuts down. Right. So nothing has changed so far, but of course, stay tuned for that as well.
Right. And we've mentioned this, day-to-day operations. So your handbook should be a guideline on these different issues. What are your hours of work? And that also affects your actual work week, and how you pay your people might determine whether or not they're owed overtime. So you can start your work week on a Saturday if you want. Go Saturday through Friday or Monday through Sunday. But you should put that in your handbook. What's your standard week and standard hours?
Yeah, this is actually one place in law where employers retain a lot of rights. So it makes me super excited. I'm one of those nerds that get excited about things like that. But yeah, you get to define exactly what your work week is, and why it matters is because Carl said overtime payments. And so you have to think as a business, well, how do we structure a work week so we can cut down on overtime? And I think this is kind of one of the best areas that you can do in your handbook. So you can capture the work week how you want, so you can reduce paying overtime.
Correct. And the Department of Labor has said that's perfectly fine. Employers can find a way to reduce overtime liability. So attendance and punctuality, is that important to you? Like, honestly, some workplaces don't have a problem. It's smaller. They have a family sort of environment. They go on the honor system. People keep track of their own time. We would say that, well, we'll just hold that for our next webinar. Don't want to get to detail on that. You just might want to address how they're going to get paid. Is it electronically? Do the paychecks go into their checking account? Performance evaluations and salary reviews. Only caveat at this point I would say is that when you get to that point, that you use language that gives you some wiggle room, something along the lines of generally, or as far as possible, depending on production criteria, the company provides performance evaluations around the annual anniversary date. So something along those lines. Confidential information has been a hot topic with the National Labor Relations Board. We'll touch base on that. We'll definitely get into that in more detail later on. But you want to address confidential information. Electronic communications is a big deal. That's your social media. I would say for today's purposes, would just say that in your handbook, you really ought to tell your employees that they have no expectation of privacy, and that the electronic devices should be used primarily for business purposes. Anything else you want to add on that?
Nope.
Nope. Okay, we've already, I think, hammered to death the benefits part, so I'm just going to skip through that. Elizabeth?
All right. So leaves of absence tends to be one of those areas in employment law that cause the most headache for employers. So we have dedicated, as we've mentioned, a whole separate webinar on this, but it is important just to make note that if the FMLA applies to you, that you should put that there. Employers are required to give notice to employees that they are entitled to FMLA. So this is the easiest way to do it if you have a handbook, rather than upon employment having to give them all these documents, all this paperwork. It just makes it really simple. You can also address what happens if they're jury duty or need to be a witness in a court case. One trend is, I think there's a lot more litigation about pregnant workers, and what do you do with mothers who need breaks for nursing? Where does that fall? What about bereavement leave, or military leave, PTO, short-term disability? So, there's a lot of, areas that come up because we're all human. We all need breaks. We all have things that come up in our life that take us away from jobs from time to time. But how do you address that? What makes sense for your business and your organization? But certainly that is something that needs to be addressed in a handbook, but we're going to dive into that a lot in detail this coming year. So this is also something that really should be in the company rules and regulations section, code of conduct. So do you want to create a special code of conduct? Do you want your employees to act a certain way? If they're wearing your company logo, so I'm wearing a Bug Bean Conkle shirt, I better not be at a bar punching people. And that's a disclaimer. I don't do those type of things, but I will use myself as a guinea pig, an example here. How do I use company property? What happens if I damage company property? I had a client that, the employee damaged a company vehicle, but they didn't have a policy to say what happens if they do so. So now we have to really, figure out what to do because you don't have a policy that's on hand. So smoking, if you have an insurance carrier that says you're a smoke-free organization, you might want to put that in your handbook so employees know off the bat that they're not allowed to smoke there. Can they take smoke breaks? Are they allowed to? What do they have to do? Do they have to clock in or clock out? Solicitation. I think I mentioned this earlier. Dress code, if it's an issue, if you want them to adhere to a certain dress code, that's a great place to put it. Let people know where a bulletin board is or how they can congregate together. Starting a new job is scary, and so the best way to start a great culture is to let employees know what resources do they have, where can they go to find things that are of value of them. So the best way is to draw their attention to maybe a bulletin board or, a wall in HR or a flyers that they can have or go to when they need resources.
I would like to tag on solicitation and distribution. You might want to have something in there because if you allow somebody to sell Girl Scout cookies by way of a sign-up sheet or whatever, but you do not allow people to sell tickets for a nonprofit organization or a church or whatever, that could get you into trouble. So we'll talk more about that later in the year, but that's for today's purposes. That's what we mean. NLRB, National Labor Relations Board. Why does anybody care? Well, this is going to be drilled down, as today's corporate world says. We're going to drill down into the National Labor Relations Board and the National Labor Relations Act and why that has any involvement with employment handbooks. For today's purposes, for many, 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 many years, Lutheran Heritage Village was the case that controlled. And the problem came about with the activity of the National Labor Relations Board, especially under the last presidential administration. There were all kinds of strange interpretations that were being taken by the reasonably construed language under Lutheran Heritage. And what that means is if an employment handbook said that as an employees will be kind and considerate to each other, the board would say, well, that could be reasonably construed to mean that you can't get angry at supervisors about the terms and conditions of employment. So therefore, that handbook on its face is illegal, and that was causing problems. So this recent case came about in December of 2017, less than a year ago, that changed the analysis to a balancing test. And that's it. That's my teaser for that. We'll get into more detail on that, but it does have a great effect on all of your professionalism codes, the recording policies that you have at work, whether you can take pictures, how you interact with the public. So that's really an important case.
Yeah, so I think we've come to kind of the end of what a handbook really should look like. So we're going to wrap it up with one of the most important things that a handbook should have, which is a signed acknowledgement. So there's a couple different things. Sample policy for you. So first and foremost, you're going to want to put the right that they have received this and they acknowledge it, they've understood it. So is that the first one that's highlighted, Carrie?
Yes.
Okay. Yeah, okay. Just wanted to make sure everyone had it. So, it should read something to the extent that I understand that this employee handbook is presented for informational purposes, and then that they understand what it means to them, that they've read it carefully. So then the next one would be then at-will status. So we've talked about this and harped on this, so that they understand that they're at-will, meaning that you have not made any contractual promises to them, and that they can be hired for any reason, no reason, so long as it's not unlawful. So this is kind of sample language that you would likely see. I'll give everyone just a moment to read that over. You don't want to hear my voice reading it. All right, and then the next one. Some employers, and you might have heard of a case that recently came out from the Supreme Court that allows employers to force arbitration and individually, which means it limits an employee's right to sue the employer in court and in a class action. So if that's right for you, you're going to definitely want to have that right in the beginning of your handbook, but you're also going to want to specifically mention that they acknowledge and understand that they're waiving their right to sue in court, and also potentially, say, if I have an employment claim, that I'm going to do it with X amount of time. So, how many days? And if they don't, then they waive their right to, either arbitrate it or sue you on it. So if those things are, something that you're interested in, to definitely consult us. We'd be happy, or anyone actually, to talk more about that. But if that applies to your business and your organization, you're going to definitely want to make mention to it in your final acknowledgement. And then lastly, some employers deduct certain things from employees' paychecks, whether it is direct deposit, those kind of deductions, health insurance. So if you are deducting health insurance from someone's paycheck, you're going to have to have them sign off, and this is a great way to do so. If they damage some company vehicle or a laptop or don't turn in their keys, what are you going to do with it? You're going to deduct it from their final pay. You're going to want all that information here. I know at my last organization, we had a card where you could deduct in the cafeteria. So that was there, which was really nice. So it's kind of like these are all the checklists of things that I understand. And then you're going to want to have your employee know who to contact if they have a question of either this handbook or a policy. So provide them guidance at the very end, where to go if they have a question. So after the signed acknowledgement, what do? You're going to want to make a copy, right? You're going to give your employee that copy so they know where to go if they have a question. So a lot of times what happens is it's actually built into handbooks. The employee keeps their copy, and then you should take a copy or keep the original, it doesn't really matter, and place it in the employee's personnel file. This is so important. Let me repeat. This is so important. And once again, for anyone who wasn't listening, this is very important, right? So if you have a discrimination claim, what is someone going to do? They're going to ask for your employment policies and procedures. That doesn't mean anything if there's no way to prove that the employee knew of them. How do you do that? With this acknowledgement. Say, Susie X knows of our disciplinary policy, knows of our discrimination policy because she signed this acknowledgement. So if you can introduce that in court or in an investigation, you're much likely to succeed on those claims than if you're to not. So if you make changes to your handbook, which I hope everyone does, these really should be reviewed yearly because the law does change so much, or maybe you have a new problem at work that you need addressed. You're going to want to notify your employees that things are changing, communicate to them how and what things are changing, and then have them sign an acknowledgement that the handbook has been updated or has changed. So not only are you going to have the original, but you're going to show, oh yeah, we had a training, we reinforced it, we updated, and they signed that as well. So the last question, what do you do if you have an employee that does not want to sign it? Well, I guess there's a couple avenues. If someone doesn't want to sign your policies and procedures, maybe they're not a right fit and they don't want to work there. But definitely a signature in employment law, so this goes for disciplinary or corrective action forms, does not necessarily mean all the time that they agree with everything. So maybe they don't agree with your social media policy, or maybe they don't agree with, your smoking policy or your dress code policy. It doesn't mean that they agree with everything that's put there. That just means that they received it, they acknowledged it, they understand it. So sometimes with some great coaching, you can get people to sign it, but at the end of the day, they don't want to sign it. Maybe they aren't a great fit.
Let me ask you a quick question, because we've got about 10 minutes at most. What if they don't sign it? Do you terminate them? I mean, you've probably already made the job offer to them. They've accepted it. Maybe they haven't even started work yet.
Yeah. So, I think that's one of the things you have to use your discretion. You have an indicator that this employee is probably not going to follow your work rules and policies. Right. So do you want to bring them on board? It might be a great time to separate employment before, someone can create a problem. I think we've talked about, are you having contractual obligations in your handbook? One of these is the 90-day thing. I think a lot of people say, well, we have 90 days of employment where we can just terminate anyone for any reason whatsoever. So who cares if they don't sign it? In 90 days, we can figure it out. That actually is not a correct statement of the law. Some courts read that 90-day probationary period to actually be promised employment for 90 days. Yeah. So you have to really be careful on those types of things. And also for someone who doesn't want to follow your policies and procedures, I would probably say, oh, this is not a good fit.
Bye-bye.
Yeah. So I think we've come to the end of our presentation today, but we now are going to go through some common handbook policies that we have seen in our career and kind of talk about whether they're good, bad, and if you guys want to participate, go ahead and send us a chat and whether you think it's good or bad. So we'll wait just a moment or two after, we go through each slide to see what you guys have to say, and then Carl and I will kind of dissect whether they're good or bad. So the first one, violation of whatever policy is cause for discharge. Can we get a show of who thinks this is good or who thinks this is a bad language to have?
Violation of whatever policy is just cause for discharge.
All right, so I think the majority has it here. We got some depends in there, maybes. So this is actually not good language. So the language just cause is actually one of those legal phrases that promises something. So just cause means you have a reason to terminate someone, which also implies that a contractual obligation of employment. So you definitely don't want language like this. You're going to want to say rather, violation of whatever policy will result in disciplinary action up to and including termination. So that's the right kind of language you want to put.
Kind of promise them, and then a court looks at it, or some agency like EEOC saying, well, you promised that you would only discharge them for, quote, just cause, close quote. So, then you get in the whole argument, which just cause.
Yep.
employees are eligible for a weekly cash bonus if they meet their production goal for the week. Okay. Well, this is not good because this locks the company into an automatic obligation to pay a bonus if they meet their production goal. What if you know, you guys lose a big client and you don't have the money to give a bonus? So that's not good language.
All right. We have a no-fault attendance policy. Each time an employee is absent, they will be assessed one occurrence regardless of the reason for absence. When 9 occurrences have been incurred, employee will be discharged. How many of you think this is a good language to have or good attendance policy versus how many of you think it's bad? Very good. I think everyone got the right answer here. Yeah, this is a bad policy to have. So no-fault attendance policies actually are really popular, and there's reasons to really like it because, you know, you're going to tell your employees it doesn't really matter why you're calling off of work today. You call off for whatever reason you want, and here are your consequences. And there's something to like about that because then, you know, maybe someone just needs a personal day, but they don't want to tell you why. Or maybe someone is sick, and they don't want to tell you why, or it's not really anyone's business. So there is something to like about these no-fault attendance policies. However, the EEOC has come out to say that these can be really bad because they a lot of times violate the ADA because people typically have disabilities, and it doesn't allow for discretion. So I think the moral of the story is no-fault attendance policies are okay when you carve out exceptions and you make sure you retain discretion to give some leeway to people.
If you do not work for 30 days, you will be considered to have resigned. This actually is it's a very bad policy language, and it happens to be from one of our Bugbee and Conkle files that resulted in some significant litigation. You do not want to lock yourself into this scenario. And for starters, the Sixth Circuit Court of Appeals, which is where we sit, in its Ohio-Michigan area, the federal court has said that, you know, 6 months is reasonable to be away from work, and maybe a little bit longer depending on the disability. So, Elizabeth, do you have anything you want to add on that?
Yeah, typically whenever you have a purge date, so you say at whatever day we're going to purge employment with you, it's not necessarily good employment practice, although it might not be per se illegal. You're going to end up in some hot water when someone who is on a leave that needs just a little bit of extra leave can't get it, and you're sending these boilerplate template letters that say, oh, our records show you haven't worked in this many days, so you're just automatically terminated without doing some more investigation. But we'll get into that even more later this year.
Couple more?
Yeah, so I think we're running short on time. So we're gonna probably wrap it up quick, but confidential information, so you can't share confidential information such as personal, financial information. So this is kind of in between. You know, you can tell people not to share confidential information, such as trade secrets or company information, you know, sales numbers, but you can't restrict an employee's right to talk about their terms and conditions of employment and also their own personal wages. So this is kind of it depends.
Yeah, and that language preventing and threatening discipline against somebody for discussing their personal employment environment or their personal wage information actually violates Section 7 of the National Labor Relations Act, and that's one of the things we'll talk about in a later webinar.
Yeah, and I'm going to say, though, it's because anytime you think of something that chills an employee's right to talk about their employment, that's when it starts to become a violation of Section 7. So I think we are actually at the very end of our presentation. I think we had a few more.
We got more. Let's go to the very last one. There we go. And this is sort of a nice way to tie the bow on the webinar. We talked about this a couple of times in the webinar. The following disciplinary steps will be taken in all cases of discipline. Now you have just locked yourself into having to follow this disciplinary process. Suggestion would be within the discretion of the company or the sole discretion of the company, we can elevate to immediate termination of employment. And you can say that many different ways.
Yeah, and so disciplinary policies are never a one-size-fits-all, right? So if someone is, I don't know, wearing the wrong PPE the first time in the whole world, that might not be the biggest violation, but if someone threatens another person at work, that might, require a different type of attention. So you're always going to want to write in discretion whenever you're making policies so that you can react accordingly. You never want to make anything absolute when you're doing this handbook.
Yep. Well, we definitely appreciate your time today. Thank you very much for attending the webinar. Any comments or questions, please contact us.